Welcome to Under One Roof's Landlord and Letting Agent webinar series, made possible through the generous funding of the Safe Deposit Scotland Charitable Trust. The webinar will start momentarily. For those who are joining us for the first time, Under One Roof is a free independent service that supports landlords, letting agents, owner-occupiers, factors, local authority housing officers, and others throughout the sector with issues around owning and maintaining a tenement flat in Scotland. Last year, through funding from Safe Deposit Scotland Charitable Trust, the Scottish Government, and local authorities throughout Scotland, we attained charity status, which has enabled us to hire full-time staff dedicated to working with landlords and owner-occupiers of tenement flats and those that support them. In the coming months and years, Under One Roof will be increasing the information available on our website, our Twitter, Facebook, and Instagram accounts, and through our monthly newsletter. We encourage you to share information we send out with those in your building or in your sector to help us improve the quality of tenement flats in Scotland. Today's webinar will last 1 hour. We encourage you to post your questions and comments into the chat box at the bottom of your screen. The information provided in this webinar is designated to help you understand your rights and responsibilities and to understand what professionals tell you. Any technical information on repairs is designed to help you spot problems with your building and then understand quotations from builders so you can get the best job carried out for the best price. But every building and every group of owners is unique, and so are their problems, which is why the information presented in this webinar can only act as a general guidance. It is not advice or a recommended course of action. When it comes to action, you should always seek professional help with anything more than a simple problem. More details and our legal disclaimer can be found in the About Us section of our website. Finally, if you are a housing professional wishing to record your attendance as CPD, please visit the webinar page on our website so you can log your participation and receive a confirmation certificate. Thanks for joining us. Let's begin. Hello, and welcome to the latest in Under One Roof series on landlords and letting agents webinars. My name is Mike Heffron, and I am the Chief Executive of Under One Roof Scotland. I'd like to thank everyone for joining us today. We have a very interesting and informative webinar coming up on legal issues, specific legal issues that go beyond what's in the Tenement Act. Many of the issues that we deal with and information that we give out to people relates to things that are within the Tenement Act. Today, we're going to take a step outside of that and take a look at some of the issues that affect landlords and letting agents that isn't dealt with that in things within the Tenement Act. So I wanted to let everyone know, if you've not joined us before, you can see the chat room that's up on your screen. There is a chat function where you can comment on different issues that come up. You can also post your questions within the question and answer chat room or in the general chat room, and we'll just move it over. We will get through them over the course of the next hour or so. We're about to see a video that I've recorded with the presenter that's going to be joining us, Andrew Stevens from Edinburgh University, professor there, and a former member of the Scottish Legal Commission, who sits on our board and will be giving us some information and insight into issues that may not be directly related to things within the Tenement Act. Now, of course, there will be, if you do have a question that relates to something, a legal question that revolves in the Tenement Act, you're welcome to pop it in as well. We will try to get through as many as we can today. If we don't, drop us an email at info@underoneroof.scot, and we will get back to you shortly if we do not get to them over the course of the next hour. Coming up, we've got an interview that I conducted with Andrew a couple of weeks ago that dealt with a number of issues that we thought would be as a good starting point and issues that regularly come up that's outside of the Tenement Act. So what we're going to do is show that video, have a chance to, of course, put questions and comments in during the course of that interview if you'd like us to address it, because Andrew will be joining us, of course, in the second half of the hour to address any questions that have come up. We've got a few that have come in already. And a couple other things to note, and I'll reiterate at the end, is just one of those webinars we have to make perfectly clear that this is not advice, particularly not solicitor advice. This is information. So if there's anything that you think that is relevant to you, you should first make sure, particularly on legal issues, you should first check with a solicitor yourself, not take this as legal advice by any stretch. This is just information that we are hoping to provide to give you a little bit of guidance in where to go next. And finally, I've got a couple of small children that I'm home with during the Easter holidays, so we might get a special appearance by my children. Hopefully, they've been asked to give us a little bit of quiet time for the next hour, but apologies if I have to mute myself and quickly drop off the screen while Andrew's talking, and that's probably just to make sure that somebody has a glass of water. So anyway, without further ado, we'll crack on with the interview with Andrew, and we'll see you back here in about 25 minutes. Thank you. Andrew, maybe we could first talk a little bit about first of all, describe the Tenements Act, and then we can get into the other areas that aren't covered by the Tenements Act. Talk a little bit about the importance and a little bit of maybe even the history of how we came to a point where the Tenements Act from 2004 came about.
Sure. The Tenements Scotland Act of 2004 covers most of the law in relation to flats, in other words, tenement buildings in Scotland. It's what can be described as a codification. In other words, putting the law in relation to a certain matter all in the one place. And it replaced the law as built up by the courts, and that we can refer to as the common law. But we have a challenge in Scotland in that our population is relatively small. We're a population of just over 5 million. And because of that, the amount of case law that comes to the court is smaller than somewhere like England, where the population is 10 times bigger. So because the law was solely resting in terms of court decisions and writers who had attempted to set down the law from such decisions that existed, and maybe drawing on other sources such as Roman law, there were gaps. There were real uncertainties. So, for example, it was not clear who owned an entry phone system. So did the relevant flats own the whole thing, or did they own the handsets separately, etc.? There was no decision on entry phone systems or on fire escapes. So does a fire escape on one side of the building belong just to the flats on that side, or to all the flats in the building? So there were gaps, and that was one of the big problems before the Act. The second big problem was that the Act had addressed the problem, that there was a lack of management scheme at common law. So when I referred to the first problem as being uncertainty, in other words, that was about where we simply didn't know what the law was. But the second issue was an issue of a gap, a big gap, that there was no management scheme. And therefore, the flat owners had to rely on the general law. That often was the law of common property, whereby everybody had to agree, so a majority would not be sufficient. And there were also general rules of law whereby management and indeed responsibility for repairs went by ownership. So if it was the commons there, that was all right because it was owned by the flats and they would share the costs. But for the roof, the position at common law and indeed in the Act is that the top floor flats own the roof above them. The titles can alter that. But if they don't, the position is that the top floor flats own the section of roof above them, and they, before the Tenement Act, were therefore solely liable for the repairs. The titles could make the position be that everyone shared the cost of the roof repairs, but if the titles were silent, then the top floor flat owners alone had to pay for the roof, and that meant when you were buying a top floor flat, your solicitor had to be very careful and check what the position the titles was. So in broad terms, the 2004 Act put the law pretty much in the one place. It filled gaps in our understanding of the law. It introduced a management scheme called the Tenement Management Scheme, and it introduced fairer default rules. So in particular for the roof, essentially all the flats are liable, rather than the default position before the Act, whereby it was only the top floor who had to pay for the roof.
And how do you think? I mean, I think you know this issue inside and out. And I think you might have even been involved in sort of back in 2004. Correct me if I'm wrong on that. But how do you think that the Act has aged over the last, coming up on 20 years now?
Law reform is like painting the Forth Bridge. It never stops. And I think the 2004 Act was a huge step forward for the reasons I've just given in terms of the problems before that Act. But what has become clear is that there is still a significant problem with lack of tenement maintenance in Scotland. And that's what led to the work of the Scottish Parliament cross-party working group that I was involved with. And as a result of that work, the Scottish Law Commission, which is the public law reform body in Scotland, which was responsible for a report which led to the 2004 Act, so in other words, that legislation started with the Law Commission's work, has now been asked by the Scottish Government to look at the recommendations from the working parties, the working group's report, and in particular to look at the idea of compulsory owners associations. So the thinking is that if each tenement has to have a working owners association, matters such as maintenance will be attended to more efficiently than under the present position where there doesn't have to be an owners association. Now, there are technical issues here in terms of how this relate with what the title provisions say and all the rest of it. So I think it's been the right decision to ask the Scottish Law Commission to look at that. There were two other headline recommendations in that report. One was for compulsory 5-year inspections, and the other one was for compulsory reserve funds. And again, the Scottish Government is looking at these. So I think we can expect further legislation in the coming years. The Owners Association proposals do have certain technical challenges to them, and I think the Scottish Government is now saying that the Law Commission should report by either 2025 or 2026. So this is not going to happen tomorrow, but there's no doubt, as far as I'm concerned, that there's going to be more law reform here.
Yeah, no, it sounds like very much it's going to be in the next Parliament that we see, that we're potentially seeing some stuff. Though hopefully sooner, because as we've talked about in some other forums too, is that it would be there's a lot of stuff that really could be moved along and helped with tenement owners with some of the passages of these things. But we shall see. So we will watch this space. Now, if you could, that's the Tenements Act, and maybe you could talk a little bit about sort of the non-statute law and how that, and we can get a little bit about how that sort of then interplays with some of the issues that tenement owners face.
So we can broadly divide law into two categories. First of all, there's statute law, which is passed by Parliament, and that could be the Westminster Parliament, or increasingly, given devolution, Holyrood. And property law is a matter which is within Holyrood's competence. So further legislation on tenements will be done by Holyrood rather than by Westminster. There are one or two things around the edges. For example, gas is currently reserved to Westminster, and there was a recent secondary legislation on gas services in tenements. But for the most part, legislation in this area now will be for Holyrood. So that's the first category of law, which is statute, and that for tenements, particularly, it means the Tenement Scotland Act of 2004, which we've discussed. And the second main category of law is generally known as common law. And common law, which unfortunately can mean other things. Common law sometimes means English law, or systems such as Australia, New Zealand, the States, Canada, based in English law. But for our purposes, common law means non-statute law. So it's law coming other than from Parliament.
And the way that this interacts with, the landlords and letting agents and others that sort of watch these webinars today is it just point a little bit to the need, and we stress this here at Under One Roof too with all of our work, is that we offer information, but ultimately you seek professional. We ask you to seek professional advice. You heard me say that actually in the intro to the webinar today, and this is a good example of that. This is something, I mean, when you start, if it's not for stuff that's not in that Tenement Act, that's non-statutory, this is where it's really necessary to go and seek out the counsel of a solicitor. And there are costs, of course, that go along with that, but there's also some assurance that you're getting that the kind of information that you've just been talking about. There's somebody that can draw upon these writers and what has been said and what courts have determined and in the past to give you an indication of how they would likely rule on the particular issue that an owner of a flat is bringing forward. Is that right?
It's like going to a doctor. You could diagnose yourself using Wikipedia, but I think it's much better to go to a doctor. And the same ways one can now, compared with before the internet, which was pretty much impossible, you would have to go to the city library. With the internet, one can obviously fairly easily put words in and try and get answers, but I would counsel very strongly about getting professional legal advice.
Well, let's talk about a few of those issues that are on the fringes. So one of them, maybe talk a little bit about one I thought is fascinating that we were, the two of us were talking about a little bit earlier, was the right to light. So what is or is not the right to light in Scots law?
The right to light is something which has a provision on it in the Tenements Act, which I think was based on the law before. There's a limited right of light in the Tenements Act, in Section 9 of the Tenements Act, which says that flat owners are not allowed to do anything which interferes with the natural light of the building. Now, I think in practice it would have to be the ground floor or the basement doing something like putting on an extension, or on the basis that they own the ground around the tenement, which is the default position, although the titles could say that it was the common property of everyone. But say they planted a Lelandia hedge or a fast-growing tree, or indeed they put up an outbuilding or an extension. If that was to stop light reaching other parts of the building, such as maybe the first floor flat, that is not allowed. I'm not actually aware of any case law on this, or even before the Act, but in terms of the sort of general law here, before the Act, it's probably referred to under the subject of common interest, that there's a common interest amongst the owners of the building, and that common interest doctrine also applied and applies to the flats, in the sense that the upper flats have to shelter the lower flats, and the lower flats have to support the upper flats, and that's also in Section 9 of the Act. So it's part of something called a common interest doctrine, which has now been put into statute in Section 9 of the Act. So there is this very limited statutory right to light in Section 9 of the Act, but is there anything wider than that? And the answer is basically no. There does not seem to be a general right to light in Scots law. So you cannot simply say to your neighbour, I don't want you to put the extension up because it's going to interfere with my light. Now, depending how big the extension is, they will need planning permission. And of course, you can make an objection to their application for planning. You can do that. The other thing to mention is that there may be something in the titles. So there may be something in the title deeds for the neighbouring property saying you cannot build, or you cannot build above a certain height, or you cannot alter these sorts of provisions. So what I would say is, if your neighbour is about to put up something which will block your light or view, to order up their titles and have a look. Now, alas, the mere fact that the titles say that they may not build further or build in a way which interferes with light does not automatically mean you can stop them doing it. You would have to show that that their titles were intended to give you the right as the neighbour to stop that. So you would have to show that you have something called title to enforce the condition, and secondly, that you have interest to enforce the condition. And interest as a statutory test in something called the Tenement Conditions Act, which we'll talk about, I think, later as well. You have to show that the building would cause you material detriment. So something like a sort of slight shadow for 5 minutes as the sun goes up will not do. It's going to be something more serious than that. So my advice in this situation is to get the titles for the property that is seeking to do the building and have a look at them. If there's a prohibition in them, the next question is whether you can actually enforce that. And again, it's probably the right thing to do is to seek legal advice at that point.
Well, that's fascinating. And something that's actually sort of connected with that is the right to access neighboring land for maintenance purposes. And this has come up actually even, in fact, I've just been going back and forth with an inquiry that has come in about there's a building and they are trying to do some exterior repair on the back end of the building. The back of the building just basically is right up against a parking lot. And the parking lot is owned by someone else who rents out those parking spaces and therefore has income that comes in from those parking spaces. And so there's a question about whether or not and what needs to happen to ensure that the building can get repaired, but that and how that interacts with the owner of the adjacent the neighboring land. So talk a little bit about this one, because I think this is something that probably could come up frequently or more frequently with some of the people that are watching today.
It's like the last one, which is that there's a starting point within the Tenement Act. Section 17 of the Tenement Act says that you can access other parts of the building. So there is a statutory right of access within other parts of the building, and indeed the garden ground, in my view. So say the ground floor flat owns part of the garden ground individually, and you needed as maybe the first floor flat owner to put a ladder up or scaffolding up. I think you can do that, but that's within the tenement itself, or the garden ground that is owned, or surrounding ground more generally, which is owned by the flat owners. So there is a provision dealing with that, which is Section 17 of the Act. There is, however, no statutory rule on neighbouring land. Generally, in England there is, but in Scotland we don't have that. We seem to have a gap. So what do? We look at court decisions and we look at writers. And one institutional writer, Hume, that I mentioned earlier, did have something to say on this back in the 1820s. He said that I think it may be maintained with respect to properties in a borough, which in many instances, owing to the crowded situation of the building, cannot be repaired without some temporary interference, as by resting ladders on the next area or suspending a scaffold over the next area, that this slight and temporary inconvenience must be put up with from the necessity of the case. So he is saying that there is a right to do this on a temporary basis. Until last year, the courts had never referred to that passage, but in an appeal decision in the Inner House of the Court session on rights of access, that passage was referred to and in principle stated to be the law. So that is an example of writings coming into the law through a court decision approving them. So it would seem now that we can say you can go onto your neighbour's land if you need to carry out repairs to your land. You should do it in the most limited way that causes the most temporary inconvenience to your neighbour. I would suggest practically that you should notify your neighbour and tell them what you intend to do. In fact, you might start by seeking permission to do it, but if they're difficult, say, well, in fact, you are entitled to do that, but acting reasonably. You asked me, Mike, about paying, about compensation. That is not mentioned in Hume, as far as I know, unless it's in some other passage that I've missed. And it wasn't mentioned in the court decision last year. The English legislation says there is a right to compensation, and that is my assumption is the position of Scotland to where the court's called to decide upon it. So if it was a situation which you described, whereby there was a parking area, perhaps let out to people so they could park their cars there in a city centre situation, and the cars couldn't be parked because the scaffolding had to go up for a month, then my view is that the owner would have to be compensated for that at a fair price, if you like, and no doubt that would be something on which there could be disagreement as to what an appropriate price would be. Again, I would suggest the right thing to do is to take a solicitor's advice.
Speaking of neighbours, what about damage that is caused by neighbours? How does that sort of relate to the conversation that we're having right now?
Damage is generally a matter of common law. If I damage your property, or indeed if I injure you, and you have to get medical treatment and you lose earnings and all the rest of it, you're entitled to compensation. So that is in general a matter of common law. In Scotland, we call it delict. In England and America, it's called tort. In other words, it is the case where someone has breached the rights of someone else and caused them harm or loss. It might be bodily or it might be to their property. So in principle, if one part of the tenement causes damage to another part, there will be liability in terms of compensation. The classic might be something like water leaking down from up above. That situation, it seems to be the case that fault or negligence has to be shown. In other words, if it was freak, if it was a lightning hit the building and damaged it and water came down, there would not be liability. But if the owner above knows the water is dripping or pouring and does nothing about it, they're at fault. and therefore, in principle, they're liable to compensate, or their insurer will have to compensate. That is the position. Now, of course, what happens if they don't? Again, you're into a solicitor, and ultimately you could be into a court case. I mean, I think that these sort of things emphasise the importance of insurance, which is required under the Tenement Act, and that I think a block insurance in particular is a valuable thing to do.
And also probably is taking a look at trying to stay away, especially with this kind of stuff, is trying to figure out a way to resolve this without going to court. Because in this situation, and we've stressed this multiple times before, and I know you would agree with this too, is ultimately these are your neighbors. And yeah, you might win the actual case, but you may be living with this person for the next 40 years. It's best to try to find a resolution, a mediation, bringing a mediation, figuring out a way that, yes, you may not get all the compensation that you believe that you're owed, but there is a sort of a value, a very important value that it's hard to put money on, as far as sort of having a good relationship with that neighbor as well.
I mean, one more angle on this, which I have actually advised people on in the past, is the local authority. You know, if the running water or other issues is causing so much harm that the building's becoming dangerous or substantially defective, local authorities have certain powers to put on statutory notices. There are health and safety issues, obviously, with a building that is not safe. So contacting the local authority is a possible way of moving people into action.
And that brings up an interesting point. And just to wrap things up a bit, is that we're talking about the legal side of things, but there are lots of other things that you can bring into this. You talked about earlier, we were talking about the right to light, and yes, there may not be something written down in no statutory right to light, but there's planning permission. There's ways to insert into the system. There are some of the things that we're talking about right now. There are ways going through the local authority, working with the particular sort of elements of that. There are ways you can still get done what you need to get done, or have redress against certain issues, without having to go through the legal means to do so. We're talking through these issues today, and I think it's absolutely fascinating that we are. But there are other options. And I mean, one last thing, and probably a question that'll come up, is like, well, why don't we have laws to cover all these things? And you mentioned that England does. And I assume the answer to that, and tell me if I'm wrong, Professor, but assume the answer to that is because the youthfulness of our Parliament.
To some extent, Westminster was relatively good on what might be described as technical law reform, this sort of thing, prior to devolution. So, for example, the mortgage legislation in Scotland comes from 1970, from the Westminster Parliament. That's something that Scottish Law Commission is reviewing at the moment, along with tenement law. There's only so much legislative time, and it's the government that control the legislative time, and political priorities will come first. So that can hold up more technical law reform. Parliament doesn't settle a year. There's only so many slots for bills for new legislation, and that means law reform can take some time to achieve. And as I said earlier, it's like painting the fourth bridge. More needs to be done. I mean, life, of course, is more complicated. There's all sorts of developments in society, in technology, and the law then has to catch up. So we just have to keep going.
Yeah. Thank you very much for joining us, joining me for that conversation. And what we'll do now is have a chance to do get some questions from people and continue this conversation. But thanks very much.
Thank you.
And thanks for watching that video. I hope you found it as interesting as I did. I am very happy to say that we are joined by Andrew Stephen, a professor of property law and the Law Library Committee convener at University of Edinburgh. Welcome, Andrew.
Hi, Mike.
So yes, we've gotten in a number of questions. Thanks for people for submitting them, and some good ones that we'll just get through. Again, encourage you to pop any questions that you have into our chat room, and we'll get through them over the course, hopefully, of the next 25-30 minutes. But if we run out of time, like I said, drop us an email with your question, and I'll send it over to Andrew, and we'll get you back some information on that. First up, we've got a question from Liz. Liz asked, the attic flat has a burden of the upkeep of the roof. All the other properties have a burden of the upholding of the roof. Is there a legal difference? And if so, what is it?
Not as far as I'm aware. What happens when properties are sold for the first time after they've been built is that there's conveyancing done. In other words, the solicitors do the title deeds for the first time. So what may have happened here is it's been different solicitors for whatever reason. Maybe if flats originally let out for some time after the building's constructed, so the selling off of them's not done until much later on, you can end up with different solicitors using different wording. But in my view, there's no a legal difference between the two of these. I mean, of course, I've got to caveat that and say that a court would look at the wording of the deed as a whole. But in terms of just the two words, upkeep and uphold, I would not say that there's a specific legal difference between them.
And Liz also had a follow-up that she was asking, do students ever do case studies? And if so, would they be interested in looking at our block where two tenements built at different times with different titles are linked by a common passage and stair?
Yes, a number of the Scottish law schools do a pro bono work. In other words, free legal advice. So my own law school does that. We've hit, unfortunately, bad timing, at least as regards my own law school, because it's during the academic year. So students do this sort of from late September through to the end of March. And alas, we're now, as we record this, heading towards the middle of April. So it's not with vacation work which goes on, at least at my own institution, over the summer period. But if it's something that can wait, I don't know whether you are in Edinburgh or Glasgow or somewhere else, but if it's something that could wait till the autumn when the new university year gets going again, there are opportunities to go and get advice from students on a pro bono basis. At my own institution, they are supervised by a practicing solicitor, so it's not just the students on their own. And I'm sure that's the case at other law schools as well. So yes, that is a possibility. But alas, if we'd been doing this in the middle of September, it would have been much better timing. But yes, that is possible.
We've been running a couple polls, and Jazz, who you don't see here, but is doing all the fantastic magical work in the background to make sure this runs smoothly and gets the questions up, and provide information in the chat room, has asked a few poll questions. She's asked, do you know where to get information about the Tenement Scotland Act and beyond? And of the people that responded, we've got 70% said yes, but 30%, 5 people have said no. And on a similar question, how confident do you feel in understanding the Tenement Scotland Act? We've got a mix of responses, majority of which are within the slightly confident and non-confident range. Now, we provide a lot of information on the Tenement Scotland Act on the Under One Roof Scotland website, and Jazz can pop up a link there. Andrew, would you generally, as a first point of contact, is that where you would generally send people if they wanted to find out some basic information about the Tenement Scotland Act? Is not to talk up our own work, but do we provide a pretty good sort of summary of those things on our website? Are there any other resources?
I indeed give the website to my students as well now. So as a a really helpful, um, accessible source of information in relation to the legislation. So yes, that would absolutely be my starting point. If you were a law student, you would also look at textbooks, but they, to an extent, assume legal knowledge, so that they assume you know how to deal with a case. So in other words, you know how to go and look it up. So I would very much use the Under One Roof website. All legislation in the UK can be accessed free of charge on legislation.gov.uk. So you can look at the Tenement Act directly by just, to be honest, just typing it into Google, because Google will then take you to it in legislation.gov.uk. But that is the bare words, if you like. In other words, the pure form of the legislation. Whereas what you get on Under One Roof's website, or for law students, a textbook, is a gloss. You get a bit more, a commentary on it. So yeah, I would definitely start with Under One Roof's website.
Well, that is enough talking up ourselves there. We've got another question from Malcolm, which I believe we took a look at a little bit earlier, and I think it covers a little bit of both Tenement Act perhaps and non-Tenement Act issues. But I'll read it out here. I have a situation where a tenement property was originally built with 8 flats, but with the 2 lowest flats each comprising 2 of the 5 floors. Now, the original title deeds state that all the 8 flats pay 1/8 of the common charges, i.e. an equal amount. Subsequently, one of the 2 floor flats was converted into 2 separate flats, 1 on each floor. And I think only their title deeds were altered to allocate 1/2 of the original 1/8 share to each of those 2 flats, i.e. 1/16 each. Now, recently, the owners of all 9 of the current flats agreed that this was unfair, and each of us now has a separate written agreement with the factor that all 9 flats will pay an equal share of the common charges, i.e. 1/9 each. However, this is a vulnerable arrangement, as any new owner of one of the 2 split flats could probably insist on just paying 1/16 of the share. So is there any way of making the agreement of equal shares of the common charges from all the flats permanent, without each owner having to change their title deeds through their own lawyers, which would be complex and expensive? This is absolutely sort of gets to the core of a number of issues that we've dealt with over here. But
and unfortunately not. It's the short answer. If you want to do something which will bind successor owners or third parties generally, you have to change the title deeds. So an agreement that has been made by the owners for the time being will only bind those who have signed up to it. So that the only way to make the arrangement for sharing the costs permanent is to change the titles. Now, it could be done as a single deed. So it could be done as one deed rather than as 9 deeds. So that can simplify it a bit. But you would need to get each owner to sign it, which is maybe not a huge problem. If everyone's agreed, my advice is you would get a solicitor to draft it rather than trying to draft it. So that will obviously incur expense. The other expense issue is registration. And each time you register something, although it's a single deed, because it's been registered against 9 properties, you will incur a registration fee for each. Now, off the top of my head, I think we're talking around about £1,000, adding together the registration fees and going to a solicitor, but it could be more than that. So yes, alas, it's not cheap. It's also complicated with the fact that lenders and many people of mortgages will have written into the mortgage that they need to be involved if there's a change as well. So that makes it even more cumbersome. Now, I doubt a lender would object to what has been proposed here. It seems, fair. It doesn't, in other words, it's not changing it so that one flat is liable for the whole amount. It's dividing up the share. So I doubt a lender would object, but formally the terms of the mortgage will require lender consultation. So it's not, I'm afraid there's not an easy answer. Now, I had a bright idea, but I have reservations about my bright idea. My bright idea was just to change one title and not 8 or 9. Because what the Tenement Act says is if the express provisions don't add up, then they're ignored. So if you, say, had 4 flats and the first 3 were a quarter each and the fourth was 0, so the liability added up to 3 quarters rather than to 4 quarters, in other words, 100%. What the Tenement Act says is you just ignore the burdens because they don't add up to your 100%. So my bright idea was to everyone to consent to changing one title, which would knock one out, which would then mean you only got to 7/8 or whatever, and then the Tenement Act would come in. Now I haven't fully thought this through, so I have reservations, but there's actually a problem with this. What the Tenement Act says is that liability is normally equal, but it's not equal if there's a flat which is more than 1.5 times the size of another flat. Now, on the situation described here, if 2 of the flats are a subdivision of one of the 8 original flats, I think the chances are that these 2 flats are, in terms of floor area, are less than, or sorry, are more than 1.5 times smaller. If you're following me, in other words, they're disproportionately different in floor area to the extent of 1.5 times the other flats. So my sort of cunning plan of knocking out one flat so that the burdens don't add up to 100%, and then the Tenement Act comes in. The Tenement Act would then not come in to give equal liability, in other words, 1/9 each. It would come in, I think, assuming there's this disproportion in terms of size, it would come in to say the liability was based on floor area, which is not actually what the owners seem to want here. They seem to want equal liability. So it looks like my cunning plan doesn't work, and we're back, I'm afraid, to everyone agreeing and signing and paying registration dues. And I said £1,000. It could be more. Right, I'm afraid.
And when you said £1,000, is that per person or sorry, per
no,
flat? Or
total. I think when I last looked, a kind of registration of a deed against a property. So not a transfer, not a mortgage, but a sort of miscellaneous deed against an individual property was about £60. I can just check that again. So if there were, was it 9 flats, what's that, 540? But then you'd have to put your lawyer's fees and VAT on lawyer's fees above that. So that's where I sort of plucked that figure from. But the lenders, if the lenders then say they want to be advised, then it's going to put it up. It's going to put it up further. So there's really no, I'm afraid there's not a quick and easy answer to this one. attractive as what it's being thought is. Ultimately, a title deed change is needed, and that involves, in my strong advice, a solicitor doing it and a registration costs.
Well, this is a good example of when my 8-year-olds ask why they need to learn fractions. That this is exactly the reason why, so they can sort out their title deeds when they get much older. We've got a question from Anne here. Now, Anne says, currently I have a problem in a tenement with rot affecting common close walls and internal to a ground floor flat. The rot is emanating from a ground floor WC, possibly due to a broken drain. The WC is not a common responsibility shown on deeds as belonging to 2 ground floor properties. The owner of one of the ground floor properties refuses to communicate with the factor or other owners, paying nothing towards common repairs, etc. This owner will not be interested in repairing the fault and subsequent damage. The rot is spreading through the common close and will cause significant continuing damage. Now, do the other owners have the right to access the WC and have required repairs? Have the required repairs carried out? If so, can the owners take court action against the owner to recover the cost of repairs paid for on his behalf? And just as a comment, this raises the issue of who should pay for the repairs, all owners or just the owners responsible under the title deeds. So there's a few questions in there. Andrew, do you want to take?
I think this is one I would have to probably go and think about. I mean, ultimately, yes, if somebody is not cooperative, then your options are to see if the council can do something about it under their powers, which I mentioned when we spoke in the interview, or to resort to court action. So these are really where you are left. If I'm understanding correctly, the water closet, the toilets in the ground floor flat of the owner that's not being cooperative. So I under the Tenement Act, you can access other flats on giving notice unless it's a health and safety issue. I would need to go and check the exact words, but you generally have to give notice there's a right of access to other flats to carry out repairs, but it's generally framed or aimed in terms of the kind of the building as a whole. So in other words, say the outer wall has issues, you could seek to take access through somebody's flat to carry out those repairs. The toilet, however, is more the individual property of that flat itself, and I'm less confident that you would have power to go and carry out repairs to somebody else's toilet within their flat. If it's the drains and the pipes, then yeah, clearly they have a wider concern for the building as a whole, and yeah, and the Tenement Act says effectively you own pipes which serve your property. So assuming your property is served by these pipes, then you have responsibility for them and would be able to carry out repairs for them. But I think this is one I would maybe want to look at more carefully, and we can maybe come back to you on it. But ultimately, if someone's not being cooperative, you're left with public law, which is really going to the council and seeing what they could do, or private law, in other words, taking your own legal action via the court. And again, as I said in the interview, litigation is something which it's really best to avoid if at all possible. The costs mount and the stress mount. So if there's any way of trying to achieve a result other than through litigation, it is well worth doing. But I can reflect on that one maybe a bit more,
And-
because it's got quite a number of questions, as you say, Mike.
Yeah. And why don't you drop us an email at info@underoneroof.scot. I'll pass that over to Andrew, and we'll get back to you a little bit later on. And Andrew will have an opportunity to, if he has any questions, just to quiz you a bit more about that. We've got a question from Elizawati, who asks, do you think the current Tenement Act 2004 support landlord owners in retrofitting their flats and meeting the minimum energy efficiency standard, i.e. the heat and building strategy, which is to achieve EPC-C by 2033. This gets into a question of whether or not, Andrew, I believe this gets into a question of whether the Tenement Act, where that falls within the Tenement Act. I know insulation falls within the Tenement Act, is my understanding. It's not specific though about other retrofit work. So do you know anything that you could touch upon this?
Yeah, the phrasing of the question struck me somewhat, because it says that does the Act support owners in retrofitting their flats? So as a general statement, you can do what you want in your flats. Now of course, that is a general statement. You can take down internal walls that cause the building to collapse. But broadly speaking, you own your flat individually and then can do your own things in your own flat. And indeed, the default position is you own the section of outer wall round your flat, so you could change the windows, for example, because they're your windows, they're your bit of wall. Now, I said general. I would strongly advise checking your titles, because what you're getting your solicitor to check your titles, because your titles might say the outer wall of the whole building is common property, in which case you cannot start doing things to your bit of the outer wall without everybody agreeing. Okay. And then when we get into parts of the building that are owned more generally, owned in common more generally, or key parts of the building, such as the roof, and indeed load-bearing walls, even if they are individually owned, they come in to the definition in the tenement management scheme of scheme property. And in that situation, there will then be wider liability for work done to them. So say the roof was to have work done to help energy saving. If that can fall within the definition of maintenance, then the flat owners generally will have to pay, rather than say just the top flat owners. Now Mike's quite right. He has quoted actually from the definition of maintenance in the tenement management scheme. And I'll quote the whole thing. Maintenance includes repair and replacement, the installation of insulation, cleaning, painting, and other routine works, gardening, the day-to-day running of a tenement, and the reinstatement of a part, but not most of the tenement building. But does not include demolition, alteration, or improvement, unless reasonably incidental to the maintenance. And I know that there are discussions going on elsewhere in relation to this. Can you say that this sort of work is maintenance, or actually is it improvement? And if it becomes improvement, you need everyone to agree. If it's only maintenance, a majority will get you there. But as I say, if it's literally within your own flat, it may be that you can just go ahead, but obviously you'll be the one who's paying for it. If it's getting into scheme property, which it would include the roof, or indeed external walls on the basis they're load bearing, you could if the definition of maintenance was satisfied, take a majority decision to do it, and then you would have shared liability. But of course, it's a very big if, and I know that there are arguments out there where some lawyers, presumably, and then local authorities maybe, but are saying one way, and some are saying the other. So I know this is a issue of current concern. What do I think? I think it probably depends exactly what you're doing. Sorry, that's maybe not the most helpful answer, but insulation can be done, but wider works, it might constitute improvement, and then you need unanimity.
Yeah. No, I mean, the fact that it's sort of, it could go either way is actually informative in itself about what the current status is. And you expect that we would see some more clarification on that based on the Scottish government's commitment to net zero targets in private residences. We've got a few questions in. We're not going to be able to get to them specifically because I think there's some questions in there I think that probably Andrew would need to take away and have a look at. So if you don't, I've got one question left from Liz. If you've asked a question, I know a few of you have in there, Jean, for example, drop your email over to info@underoneroof.scot. I'll pass it over to Andrew and he'll have to take a closer look at it. I think just we've given the time constraints and the details that might be needed, it might be better for you to get a little bit more detailed and one-on-one information. Well, you have a question from Liz, maybe we could just quickly wrap up with. And this is, we have shops who have much greater area than some flats who never pay what their titles say. Could one of them just change their titles to force flat owners to pay more?
No. Okay. It's a short answer. You can't. The provisions in the titles will be normally enforceable by other flats, so you cannot just change them unilaterally.
Yeah. So you can't change your own title.
You can't just change them.
Yeah, it has to be.
There's possibilities like going to the land tribunal, but you cannot just unilaterally change your title deeds. But because the condition burdening you is actually designed to be enforceable by the others. It's kind of for their benefit, not for your benefit. So you can't just say, right, it's away. So no, you can't do that.
No. And I've had that question asked of me a couple times actually too. So it's that's an important one. Apologies for the fact that we haven't gotten through them all. This has been absolutely fascinating, and I've hopefully you've learned as much as I have, I think, from these conversations. So Andrew, thanks once again for joining us. We've got our next Q&A webinar is coming up in a few weeks' time. Jazz will pop the details of that in there, but it's the last Thursday of the month, the last Tuesday of the month from noon to 1, in which you'll have an opportunity to ask questions of us on any topic. So if you don't get to, again, if you've got something you wanted to ask today that we don't get a chance to get to, that we haven't gotten a chance to get to, but it can wait a couple of weeks and it's not specifically legal related, you can come back on then. We open it up to any questions you might have from your landlord or letting agent experience. And again, we'll be able to take those on. And then coming up in May for a final one in these series, we're hoping to continue these on, but the final one in this particular series is going to be on communication and communication with other owners in your building and how to better do communication and get through some of those barriers. So you can join us in a month's time for that. That'll be in May, coming up in May. So thanks very much again, Andrew, to Jazz in the background for helping us out, and for all of you for joining us today. Pass on information about these webinars. They're free, and we hope to continue going for quite a while to come. But until then, we'll see you next time, and have a good afternoon. Bye now.